Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this video, we'll be discussing the situation of an employee who's been fired, hired, and fired once again. And in the first instance, they're fired from their original company that they often have been working for a long time. And then they're hired back by a new company that has acquired their old company. So either through an acquisition or a merger, this second company has acquired the original company or its assets, hires on that individual, and then subsequently fires them. And what happens all too often is, in the first instance, the employee is provided with a termination and severance pay package. So they receive termination pay in lieu of notice, and they also receive severance pay. And this is done at the behest of the acquiring company that goes on to rehire them, on the belief that by having the original company pay them out before they come in and do the acquisition, having fired them and paid them out those numbers, the new company can then come in, hire the individual, and not have the burden of termination and severance pay should they fire that individual a short time later. Now, in some respects, that's correct, but it's a bit short-sighted because in other respects, it's not entirely to the point in law. Now, what it does do is it deals with half of the elements, which is termination pay in lieu of notice. So what it deals with is it sets up a scenario where it cuts off the statutory element that's prescribed by law and satisfies that element. Because it says there's an end, you got paid for the end, you're fully paid, move on your way. Severance pay is slightly different. Severance pay relates to a payment that is designed to facilitate an individual's ability to pursue new employment afterwards. So when a person gets paid severance pay and automatically gets rehired, and the arrangement is such, typically people don't take that severance pay, bank it away, and say, I'm going to save this for a rainy day later on down the road. They're not told that by their new hiring company. Instead, they take their money, they expend with it as they would because it's money that's being put forward to them. And if they characterize it as severance pay and they don't pursue it, even though that they know that that individual is going to be hired immediately after they've been fired the first time, it's to the company's own detriment that they made that move. And all too often, employees fall for it. And they don't really want to legally challenge it because it's a difficult challenge, although it's steeped in law. Because even if you take another 6 months or 12 months or even 3 weeks, and then the subsequent company fires that individual for the second time, technically, they are required to pay severance related to the ability of the person to find a new position of comparable character. And what all too often happens is that they perceive it as deferring back to the original firing and relieving them of the severance in the second instance. But unless the person has been obligated by some form of arrangement to bank the money, technically they don't really have the money anymore. They oftentimes dispose of the money. And now, once again, they need an actual severance as stipulated in law to provide them with the means to overcome the transitionary period to finding new employment. And that is actually how the law works. From a practical standpoint, the new employer who subsequently fires a person is going to try to direct all the parties back to the original severance and try to extinguish their obligation. And then it really becomes a question as to, even if somebody came to work for them for a period of 3 months, 6 months, 9 months, 12 months, a year and a half, are they really supposed to have banked that money on the understanding that they're going to come in and work hard, and sure enough, they're going to find themselves out of work afterwards? It's a real challenging question, a real interesting question to say the least, because it's supposed to be transitory money, and it's not supposed to be money that's based on the length of service. So as you can see, it comes into this sort of gray area, which challenges potentially a lot of companies when they try to offset this arrangement. And it allows individuals who've been fired the second time the basis with which to challenge their second employer, should they feel it appropriate. They're not going to be able to go after them for termination pay necessarily, but what they may well be able to do is challenge them for severance pay. It could be a very difficult legal fight, but it's well worth some consideration, especially where the individual is going to have a difficult time finding comparable employment elsewhere, and if there's a slight passage of time. So maybe with the 3 weeks turning around and letting go of the person at that point, it may not be the most appropriate and advantageous to challenge them. But then again, if the individual's already burned through that money from the first package, it may well be worth considering, because this is common law matters, and it's matters that are related to the ability to transition to alternate employment. And it's something that the employers fail to properly recognize, and oftentimes fail to properly incorporate into their contracts. Because there may well be, if they are conscious of this aspect, they might write it into the new employment contract, this aspect. But all too often they use standardized templates, and that is their downfall. So if you have a situation where you've been fired by your initial company, that company was acquired, rehires you, and then a short time later fires you in that period, you may be able to pursue that second company for severance, even though technically you received a payment which was designated as severance. But no, it was never appropriately severance, because the knowledge was already there that you were already going to be leaving that company and being rehired by the subsequent company. So you could call it whatever you want. It was money that was expected to be expended as some type of keepsake benefit. And that's how you should treat it, and that's how your lawyer should pursue it, if there is a case to be made. Thank you.